listing tomorrow, my lord. Motion matter, my lord. I have filed on 25 times, my lord. I love.
Item number 13 of this content matter. Mr. Monto is out of personal lordship, and I have already informed the other side of it. After 2 weeks.
2 weeks.
My lord,
On a prayer made on behalf of the petitioner. Put the matters in the joint petition after 2 weeks.
That may be it.
14th, my lord.
2 weeks.
14th.
No.
my lord, I have the same prayer for listing tomorrow, my lord.
Motion matter.
Motion matter.
Yeah.
Filed or not?
Filed, my lord.
When did you file?
Yesterday filed, my lord.
There is urgency.
Urgency in the sense, my lord, the petitioner, she is a widow, 61 years old widow, my lord. Her pension, family pension has been stopped after 25 years, my lord, without any reason, my lord. Deeply blessed.
I also have a prayer for listing tomorrow, my lord. Motion, my
Motion.
lord.
Filed or not?
We are filing it now.
Urgency is there.
Yes, my lord.
What is it?
My lord, the petitioner, a departmental proceeding was initiated at the back of the petitioner, and now he is served with a notice as to why he will not be removed, and the authority has already come to a conclusion that they will remove him, and on 2nd of September it will come into effect.
You have to mention tomorrow without a filing number. How can you mention?
My lord, I have the filing number. I have already filed it today with my clerk, my lord. It's in the registry, my lord.
Okay, try.
I'm deeply obliged.
Which is your authority?
Police department.
You are what? Constable?
Yes, I am a constable.
For listing, my lord, on 7
Listing for what?
contempt case,
Contempt matter. Which year?
to 23.
23. What is the stage? What is the stage of the matter?
In orders, my lord.
No. What is the stage? Have notice been issued? Have the respondents appeared?
Not if you are, don't know the
You
fact,
come
my
up with instructions. May mention tomorrow, not to come up tomorrow. Get the facts properly. Why do you want listing? Whether the respondents have appeared, whether they have filed affidavit. You need to know this. These are basic facts. Take the file. You don't need to consult anyone. Take the file. Yes.
May please, your lordship, back to mention item number 9. Here is,
9.
it is in the serial matters. My lord, affidavit reply has been filed from the petitioner. So may it be tagged along with the main record. Okay.
Please, your lordship, I beg to mention for listing of new petitions for motion tomorrow.
Have you filed?
Yes, Lord.
What is the urgency?
Lordship, the petitioner got selected in the final
When did you file?
yesterday.
Okay, will come tomorrow.
Please, Lordship. Lordship, I beg to mention for listing of a miscellaneous application
For
which pertains to restoration of a dismissed pension matter.
this is writ petition.
Yes, Lord.
What was the subject matter of the writ petition?
Pension matter.
Pension.
Yes, Lord.
21.
Also next week, probably.
Yes, next Friday.
Well, Lordship, not Friday.
Or then Thursday, because next week till Wednesday is closed.
Deep job. Like.
What are the serious matters, Mr. Das? What are the serious matters? You are also there.
Yes, I am chairman. Series is regarding about all these are the engineering diploma, 3-year diploma in engineering. So we are also under engineering branch. We are
taking for final disposal.
No, because today, yesterday I filed the affidavit. Department has not filed any affidavit. Only APSC is there.
Okay.
APSC has not filed. Department has to come with an affidavit.
Let them come.
Yes, AIC.
We just had a look at the series to we wanted to.
Yes.
So let us can you take it up today for disposal?
Disposal, I think, difficult unless the
Who is
affidavits
for public work?
affidavits are not being filed.
Who is for public work?
I think Mr. Chaudhary, Ken Chaudhary is there in some of the matters.
No,
Then-
for the department.
Department,
Public work. Mr. Nayak, Mr. Madam, you are there for public work. Are you looking after these matters from 6 to 6, series from 6?
No.
Someone other council allowed.
Now, what is your instruction? Can you go ahead with these matters today? Have you filed your affidavit?
I'll have to talk to our council who has
Please
been
have an
allotted.
instruction.
Because
Yes.
there are 307 posts. There is an interim order. Different petitioner has filed this case. There are some 92 posts, my lord. All this has been stayed. Now APSC may like to tell that why all these particular, they select commerce already.
APSC, Mr.
Mohanto is there, Mohanto is there. Well, let
No.
Mohanto.
Why we had asked, because if we start with the top of the list matters, it might take time. These are 12 matters. So if you cannot go for an effective hearing today in your matters, then probably we'll have a,
I think department has not filed any, department has to come up.
That's
Let them
why I
come.
informed.
let them come.
Yes.
Top of the list. Motion.
One motion is there. I think only, I have been told that ONC doesn't have a standing counsel.
This is for ONGC.
ONC.
Yes.
I think, my lord, this is a matter where I have been terminated. He was a deputy general manager of ONG medical. Now, there are some allegation was leveled against him
The termination was preceded by an
by
inquiry.
an enquiry. Enquiry report was there. By enquiry report, enquiry was done without following the procedure. My defense witnesses
When was
also.
the termination order passed?
Termination, that's why I'm not asking for any inter. 27,
28.
28/7. So your lordship will not pass now. Let a notice go and
No,
indicate.
we'll issue route.
No, my lord. He's retiring on after 6 months.
In January.
In January.
No, termination order.
My lord, there is
Any
one
interim order.
judgment. I know one
Yes, sir.
judgment of the recent judgment of the Supreme Court 2023. Why?
Termination, Mr. Das, will have difficulty in staying a termination.
No, I'm not. No, that's why I'm saying. No, my lord, what I'm saying, my lord will issue a notice and returnable within a period of 2 weeks, because I will exactly show one judgment of the Supreme Court. Now, fairly speaking, there is an appeal. After the enquiry report was furnished, we moved. The enquiry report, what it says, my lord, is self and say that there is nothing charged against me, exonerated.
Thereafter,
Thereafter, it went before the disciplinary authority. Disciplinary authority engaged an inquiry officer. Now, disciplinary authority is contradictory.
Contradicts the report.
Contradictory report. That's why I'm saying what at best, my lord, if
the disciplinary
tomorrow,
authority can defer with the inquiry.
my lord,
this
uh,
report.
So he has
it's-
to send it back.
my lord, the problem is that your lordship looks into it. I'm not troubling today.
Was notice given by the disciplinary authority
To whom?
at the stage when he had deferred to the findings favorable to you?
To me. दिया मैं ना, this one auto notice this thing,
Yeah.
it's given.
Then that
Yeah.
procedure has been followed.
No. What I'm not, my lord, level of the inquiry officer has not followed the procedure. My defense witness expertise,
Expert.
all
No, but
expertise.
you say that the inquiry report is in your favor.
No, it's a
Yes.
contradictory, self-contradictory. What I'm saying, one hand is saying that no,
Charges are not.
charges are accepted, some charges are not accepted. Well, there's a fair, that's what the judgment of 2023 says, my lord. And it has been set aside. Set aside.
No, you can tell us clearly, you are not very clear. See, the charges were inquired
Yes,
by an inquiry officer.
yes.
He has furnished a report.
He has furnished a
This
report.
report has held the charges to be proved or not.
No, not.
Some, it has been in not proof, and in some he has
How
finding
many
is something
charges
else.
were there?
There are, I think,
charges.
3 charges.
How many were held to be proved?
Only one.
One only.
One held to be proved.
Yes.
Thereafter,
Thereafter, my lord,
Disciplinary authority takes a
disciplinary authority takes a different view altogether.
Non-speaking order.
Nothing, my lord. That's why I am before this court. I know my limitation regarding termination.
no,
I-
disciplinary authority has concurred with the findings after hearing your second circus reply.
Yeah.
What is the major fault? What is the procedural illegality?
By the inquiry officer.
But the inquiry officer, he has the
Evidence,
total
what an
evidence.
expert.
Kindly see all this evidence expertise, my lord. How an expertise evidence, he will not give a fair trial to me.
So
Expertise.
where you put to notice?
I'm sorry.
Where you
Yes,
put to
I-
notice?
Short time.
No, I sought time.
Because
I
CBI
sought time because medical, my lord, I was on medical leave. I've given an application before. Give me some time. Time is not granted. No, we'll go ahead.
What are the dates of the inquiry?
Yes,
What are the dates of the inquiry?
yes.
Inquiry report is 26.
At 26, 27, my lord. 26.
Dates
Date,
of inquiry.
yes, dates of inquiry.
January to May.
January
To May.
To May.
20.
No,
23.
it was from January to May
Yes.
for 5 months. You are saying that you have been caused prejudice. Why
Yes.
did you appear before him? From January to May, you are not
No,
seeing
we have
for
appeared.
We have appealed.
We have appeared because
said
of.
ex parte.
No, yes. No. What I am saying, not
Certain
that.
proceedings expert.
Certain, my lord, with my witnesses was ex parte. My defense witnesses were ex parte. Some witnesses he has called also, that was also an ex parte. I could not appear before him because I was unwell. Then CBI has also called me in some inquiry. Also there also I made an application.
You had a defense representative.
I'm sorry.
Did you have a defense representative in the
Yes.
inquiry?
Yes.
You had. Then what facilities are you have? The rules prescribed for a defense representative. Did you have one? You said you had. Then whether you are personally there or not, how does it make a difference?
No, but your lordship will see the records, my lord. Records will reveal, my lord.
Not to
Records
see the
will reveal.
records, we have to be prima facie satisfied. Because the disciplinary inquiry, these are matters of the primary authority. Our role is very limited.
But your lordship, then your lordship will look into it. What is the inquiry report, my lord? Kindly see the inquiry report.
Page
How he went into page, my lord, started from 91,
9-1.
91.
Yes, please.
Yes. And kindly see now, assessment of evidence at page 101, page 4.0. 4.0.
Yes.
As brought out in the 4.0, as brought out in the introduction, total 26 document marked as exhibit M1 to M26 and 22 to witnesses, identified as MW1 to MW22 were produced during the inquiry on behalf of the management in support of charges. On the other hand, 5 documents marked as exhibit D1 to D5 were taken on record as defense of the document. Deposition of 2 witnesses identified DW1, DW2 were recorded on behalf of the charge officer in his absence. Now, lordship will kindly see. I am showing major one. Kindly see 114, my lord.
See, DWs are your witnesses.
Yes. Kindly see
Their statements
114.
have been recorded, whether your presence is there or not. How does it make any difference? They are your witnesses.
My witnesses, why, my lord? My witnesses, kindly see again 114.
Yes, we would have understood if the
Kindly see
statements of the adverse party witness has been taken in your absence.
Kindly see.
Yes, on one.
Kindly in 114. Into paragraph. Paragraph 47.3.
On 1-4.
1147.3.
Yes.
Contention of the presenting officer does not seem correct. Had the intention of Messrs. Kiran Clinic and Dr. Syed cheat on this account, requisition slip could have been maneuvered. Defense of charge officer or being an inadvertent error appears tenable. Subject episode only exposes the mechanical way the system works. So kindly see 115, 4.83. The allegation is based on inference without any basis. Sufficient evidence does not exist to support the allegation. Sample C's of 17 ex-employees out of 271, that too without any scientific basis, is not sufficient to draw such conclusion. As discussed under para 4.13, there is no evidence, direct or circumstantial, to suggest requisition slip.
Mr. Das, you just reading this will not, it's not the correct interpretation. These are your submissions. The charge officer has not addressed the allegation is brief.
No, kindly see that
These are
last.
the allegation. Then he says the defense brief.
Kindly see at page 119.
Come to the conclusion.
Kindly see 118. Last, in view of the above, 118.
Yes.
In view of the above deliberation,
Yes, yes.
the charges against Dr. Sai is held established to the extent he connived with Dr. E. Tamuli, contract medic OS so and so to enable Kiran Physiotherapy to claim false bills which were duly verified and certified by him for payment, resulting in financial loss to him. It is also as a additional tax I fell on so and so on account of payment made to so and so for physio against false bills were verified and certified. Charges of having fraudulently generated requisition slip for physiotherapy treatment of so and so is not established.
The fraudulent generation is not established,
Yeah.
but the connivance with Tita Modi has been established.
Now kindly see, my lord, at page 118, second paragraph 118, the
Yes.
practice of issue of requisition slip without face-to-face interaction between doctor and the beneficiary left enough scope for some unsuitable elements in impersonate a beneficiary obtain requisition slip to benefit himself vendor. In absence of convincing evidence, it would be improper to infer the requisition slip were fraudulently issued by doctors.
Let us see the order of penalty.
Penalty, my lord. Impugn order at page 126. Oh, formal part. Very nice. Page 126.
Yes.
127, 128.
Yes.
My lord, it has established during inquiry by Dr. Shah, lordship got it?
Yes.
Connive with Dr. E. Tamuli Contract Medical to enable Messrs. So and so to claim false bill which were duly verified and certified by him when resulting in financial ONC. The inquiry also assessed additional tax have failed on so and so, so and so. Dr. Shah does fail to maintain absolute integrity. This act were also prejudicial to the interest of the corporation. In the light of the above, I, as a disciplinary authority, I am the opinion. Ends of justice would be met if penalty of dismissal from service, ordinary be a disqualification of future employment, government or corporation, company owned or controlled by government is imposed on so and so. Operative part.
See, there is no jurisdictional error. We have alleged that he is not competent to pass.
No, that's what I'm trying to
Number
say.
one.
No, I'm not saying that.
Number two, so far as the procedural irregularities are concerned,
Yes.
we don't find any blatant irregularity. Our role as a 226 court is very limited in many matters.
I will just
Page one,
satisfy.
page 180.
180 kindly see my lord, page 180 of the
Third,
rules.
read as Learned Senior Counsel. Assisted by
K. Taluk.
K Taluk.
State Allocated Learned Counsel for the petitioner, who by means of this writ petition has put to challenge an order dated 28/7/2020 passed by the disciplinary authority of the ONGC, whereby a major penalty of dismissal from service has been imposed. What about the departmental appeal?
There is an appeal available.
There is an appeal available. We have said without that also we alternate remedy to 26 my lord. That we have.
Have you preferred the appeal?
Yeah, I'm sorry.
Have you preferred the appeal?
No.
No, we have not preferred it.
The senior counsel submits that on a query from the court, the learned senior counsel has responded that though there is a provision for preferring an appeal in the corporation, since there is violation of the principles of natural justice, it is submitted that availability of an alternative remedy in the form of an appeal may not be an absolute bar. That notice be issued, returnable on. Okay, I'm for appeal number 1. Returnable on when
Union.
on 28th,
Yes.
20th of September. The DJ Das accept note on behalf of the respondent number 1. Let a copy of the petition be served upon him by tomorrow. That step taken for service of notice upon the respondent number 7 by reset post. Step by. You can also do one thing. When this has got the panel of counsel, you can request them. They
I will
appear
request.
to be
Well, because that's in court number 1 matter. Nobody appeared. Court also inquired. Where is your question? There is no panel.
there is a panel. They are
Yes.
not sending counsel.
Yes.
You can make a request
No, I will make it. It will make,
informally.
that's why I thought that it will make more easier if ONC is there. Only one prayer, if not inconvenient, my lord. Yeah, on that day, my lord, if your lordship may consider, if I am fine, your lordship may reject also interim order prayer that on returnable day.
Right.
Only one prayer, my lord.
Interim order in a termination matter.
No. What I'm not today.
No.
I'm
even
not asking.
if you are successful, we'll satisfy.
No,
We
only.
cannot see an India for termination.
I'm not asking.
That's
for it.
against the established.
No, I'm not
principle also.
asking for stay, my lord.
Then and the
What
next
time I
day,
will notice, my lord, only if it is rejected, rejected. my
at
lord.
an interlocutory stage, we are not seeing. We are not making any of them. You can pray
Not
for a final.
observation.
You can pray for a final disposal. We may allow that. can make an endeavor for final.
Very limited. I'm not asking today itself. to
Termination,
the-
how can we stay at termination? Just
How
tell
can
us.
today I'm not asking.
No, even
If
on the
your
next
lordship,
day,
suppose
without hearing them.
tomorrow, Lord, I'm sorry.
Without hearing them, we'll stay at termination order.
No, I'm not saying today, my lord. If on the next day,
Das Learned City Council, praise for an observation.
not observation, I'm not asking.
Then-
No, your lordship
That on the
will
next
fix.
day.
On the next day,
Next
my,
day, the praise for an observation that on the next day, the interim prayer may be considered. Also, the state prayer is however rejected as an order of termination, cannot be stayed at an interlocutor.
no, your lordship will not observe this, man.
Sorry, I was really insisting, you have made your submission.
This we pray, my lord. We are not asking. I said on the very first day.
That is the establishment.
heard
You
it
just
on
in the appeal.
Then your lordship will hear it finally on the.
Let them come.
Since they take time and time, my
Last part,
lord.
last part we are not.
Yeah. There's only difficulty is that part.
Observation part.
I will just try to make a mention for the court on the next.
Much of
Deeply obliged, my lord.
It's become infrastructure.
Is it?
Lot.
You for Mr. Pathak for ASP. What was the matter?
They challenged the selection process, Your Lordship, on the ground that the written test was held in English. On the ground that the written test was held in English, Your Lordship.
The selection of which year?
Of 2011, Your Lordship.
How the Chaitya, as Chaitya, when it counsel for the petitioner, whereas the state of Assam is represented by Sri T.C. Chaitya, still senior honorable. So the ACP is represented by the Learned Standing Council by the process adopted by the procedure adopted in a recruitment process for bill clerk public meter readers in English medium. The state recruitment process was of year 2012. The Chaitya, the Learned Council for the petitioners, however, submit that the recruitment being of the year 2012 and there being no interim order, the matter has become mere academic. In view of this, efforts is also endorsed by the Pathak, the Learned Standing Council, the writ petition is closed. Yes.
My matter will be already in Texas now. And the petitioner is already retired from service.
You are A.N. Ahmed.
Yeah, now.
A.N. Ahmed, Learned Council for the petition. Also heard.
Health Department.
MS S. Sharma, Learned Standing Council, Health and Family Welfare Department, as well as Sri T.C. Chaitya, Learned Additional Senior Government State Assam, for state respondent. Also, the matter pertains to a challenge of an action by which the petitioner, who was working as in-charge head assistant in the GNM training school, Barpata, was replaced Why is response number 5? While issuing notice, this court by the order dated 14/3/2012 had also passed an interim order on the strength of which the petition had continued on the inquiry basis. Ahmed, the counsel for the petitioner, however, submit that during pendency of this petition, the petitioner has retired from service on attaining the age of separation. MS Sharma, the learned standing counsel of the department, as well as Sutia, the learned state counsel, has submitted that in view of such development, the matter has been rendered, and the matter has become only academic in nature. In view of the above, the writ can close.
In that series matter PWD, P. Nayak will appear, I have informed.
Is not put it in that no certificate is necessary.
We have filed in this affidavit, my lord. We have filed already.
Are they interested or none appears for the petition on call, whereas the state is represented by British Petitioner, the learned additional senior. The petitioners had claimed out of turn promotion as they were members of their devil team. It was very item. The state affidavit has submitted that certain promotions have been made on the recommendation of the selection committee, which, however, recommended selection committee. However, the cases of the petitioners were not recommended. Since none is present for the petitioner, this court is of the view that one more opportunity be granted to the petition, and the matter is directed on 100 column top of the list on next Thursday. It is, however, made that in case of further default on the part of the petition, this court would pass appropriate order. One chance, Mr.
Yes, ma'am. Otherwise, they will pay 1,000 rupees each for start.
Next day, to remind this, we can incorporate this fact also that they have already been recognized by giving one prize. Madam?
Your Lordship, I pray for adjournment of this matter. Unfortunately, Mr. A. Chakraborty, the learned argument counsel, is not keeping well.
Item number 4,
Yes, your lordship.
A Chakraborty means
Anirban Chakraborty, the arguing counsel, your lordship, and the brief is with him.
but we have because this shows names of different councils. You are in item 4 or not? Right,
Yes.
Muslimuddin Ahmed,
Yes, your lordship.
A Chakraborty was okay. Yes. He is not well.
Your-
Chakraborty is it Mr. Nair?
Yeah,
But 2012 matter, madam, we cannot adjourn like next Thursday we are fixing.
your lordship.
Council has been set January, Thursday. Up
Next
here,
one.
up here for
Thursday, there is some difficulty.
Friday.
Monday,
This month, this next Monday to Wednesday are holidays. Thursday or Friday. Cannot do 2012, man. Okay. It is submitted that pre-age of robot and council is presently looking after the matter. We stated to January, and therefore a prayer for adjournment has been made. However, considering that the matter is of the year 2012, while adjournment is granted, it is directed for listing of this matter on a particular date, which is fixed on. We'll have it on 8. If you have a difficulty, 11. Okay? But come up on 11. 11, madam. Some more time.
Pleasure, your lordship.
11. Monday.
My lord, I pray to pass over this matter for timing. My lord, Counsel Mr. B. Gogoi is occupied in another court.
Who is there?
Counsel Mr. B. Gogoi for
B.
assignment
Gogoi.
number 5 and 6.
This is for health department.
My lord.
Health department.
Again, sir.
What is the matter?
While lordship, Connect Rita DB is also on the lordship. So matter is taken up at 2 o'clock.
My lord, I'll pray for adjournment for the day, my lord. The conducting council is suffering from conjunctivitis.
Who?
Mr. SP
Talk
Sharma.
about
Mr. SP Sharma.
assistant. We will have it some other.
My lord, if it pleases my lord, can a date be fixed?
This court has been informed that the SP Sharma, who is conducting this case, is unwell. Accordingly, the matter is adjourned to be listed on 12th of September. Can it be taken up for disposal?
Yes, my lord. Pleadings are over, my lord.
Disposal on 12th, Tuesday. What is the matter?
My lord, matter pertains to selection, my lord, for the post of assistant professor of microbiology department in AIMS Guwahati, my lord.
Okay.
We are challenging that, my lord.
There is a private respondent.
There are 2 private respondents, my
Have they
lord.
appeared or not?
My lord, they have filed their affidavit in opposition, my
They have
lord.
appeared.
Yes.
Who
Opposition,
is
they have-
appearing?
probably, my lord, Mr. B. Gogoi, senior.
No, B. Gogoi is for the official.
1 to 4, my lord.
5 and 6, 5 and 6, my lord. B. Gogoi.
5 and 6 are private respondents.
Private respondents, my lord.
Or this is not the state health.
My
No,
lord,
my-
actually, I'm not in record,
AIMS, my lord. AIMS, my lord.
AIMS is not under state
No,
health.
my lord. No. As far as my humble
Okay,
knowledge.
okay.
Highly obliged.
Highly obliged, my lord.
Sorry.
12 तारीख थी।
12.
Highly obliged.
May it please the Lord. But we have filed a petition as we participate in an advertisement for the post of junior engineer. We have cleared the written, said in the fiber results are not declared. Now,
Senior counsel is there. Yes, Mr. Das. Can you go ahead today?
I don't know because the department has not filed any affidavit as on date.
Which department? Public work.
Yes.
Filed affidavit.
My
No.
lord,
Now, what is the issue? If you think that your affidavit is necessary, then we grant time. No point wasting time. But what is the issue involved?
You take one by one, I'll fly because other side because in main issue main issue is that my lord, there is regarding my lord civil engineering and civil and planning. we are APSC, we are go by the advertisement. In the advertisement, it is only the diploma in civil engineering. So the
So,
petitioner,
Mr. Mohanto, we are not the facts and merits. If you are willing that we can go ahead with the hearing today for
no,
this.
my lord, actually what happened, they are pleased that petitioners pleased that my lord, diploma in civil engineering and diploma in civilian planning are one and same. So one and same, even if it is one and same, we cannot modify the advertisement. The advertisement which was issued, my lord, that was as per the department. Which one department required? If department, because there is no question of equivalent. They strictly said that we want civil engineering only.
We are not on that. We are trying to say whether we can go for final disposal.
My
today.
lord, what is the stand of the my lord department that is not been placed before this honorable court till today?
Yes. correct.
Our
That is
instruction,
the case. We are trying to sort out the problem.
instructions.
Time, yes, last
Do
question
we
they
have
have given
the, do
time.
we have the instructions or not? No, no. Do we have the instructions or?
So your lordship kindly see the last order, my lord. Your lordship kindly see the last order.
You want to contend that the
Department
the requirement is almost the same.
No, department has to file and come with a definite, my lord.
Yes,
They have to come, my lord. Department is mandatory.
There is a stay order in the recruitment process.
No, there is no stay order. Actually, there are advertised 307 posts. 307 out of 307, 92 posts are asked by this honorable court to keep vacant. If we keep vacant 92 posts, my lord, out of 207, all
You are 92.
I
Yeah,
am not all 92, I am 33.
No, no.
Yes,
Yes, 92.
You are otherwise protected.
I am protected.
Sit and file the affidavit. But you
your lordship
delay,
kindly see the order
see.
17.8.
Having post vacancy is also not in the interest of public. More delay, the
Exactly, my
in the public interest. You come ahead. If
That's
you say
why
that they can be accommodated, we allow that.
Right.
And if you say no, then we'll hear
Yes.
whether your stand is correct or not.
Right.
Because our stand is that we are equipped and agency, we cannot
No,
modify the
you are,
advertisement.
you are almost a nodal agency.
Their role
Whatever
is
their
very
requisition will be there, you will go by that.
My lord,
My
exactly.
learned friend role is very limited. But the role of the
But he's very vocal.
very vocal, always vocal.
No, vocal, my lord, because, my
Always
lord,
vocal.
because they said, my lord,
Sometimes,
that you are
sometimes, my lord, I think that he's available for department. He's so vocal. He's for the interest of the APSC.
We
only.
thought he was not a petitioner.
I try to sort out the problem, my lord, because now, my lord, this is it. Your lordship kindly see the person who are appeared in
He
the
should have
interview.
appeared on this side. We don't like to see Mr. Mohanta on this side. Otherwise, also.
Yes.
Okay. Tell us when. Tell us when.
No, it will be too long, my lord. Because your lordship, those who are appearing in the interview, they are pressing hard to recall the result, my lord. Then, my lord, they can, my lord, clarify the
We'll
question.
fix the date after 2 weeks. Matters of which year? 23.
I'm sorry.
23 matters.
No, regarding my lord, appointment, those who are
No,
unemployed,
no,
they
matters are 2023.
my lord.
We'll give it third, three, so and so, leader. Please give the names of the council in a script. Also heard at order. Also heard the
No,
TJ Mahant.
my lord, advertisement is of 2019 advertisement.
19 advertised.
But the recruitment process had come up now.
20.
Why which were filed in 22, 23? Also heard by TJ Mahant along senior council,
Because of the COVID,
assisted by
P. Sharma.
P. Sharma. Why I think this is Mahanta, D. Mahanta. There is another D. Mahanta with you.
Not with me, but not in this case.
There can
D.
be
Mahanta
only,
is there.
my lord,
One D. Mahanta is there.
Yes, ma'am.
there can be only TJ amount of one only.
Assisted by P. Sharma.
Order to
P.
reassess.
Sharma. Full stop. The issue pertains to a recruitment exercise for filling up the post of
Junior
assistant
engineer
engineer, junior engineer,
Civil.
junior engineer civil
in the PWD department.
in the public works department, and the controversy is with regard to an eligibility criteria.
Yes.
Full stop.
Exactly.
It is, however, not disputed in the bar that the stand of the department would be relevant, which is yet to be put on record by filing any affidavit. Three, P. Nayak, standing counsel representing the Public Works Department, however, submit that instructions are awaited as the same is also to be routed to the AICTC as clarification would be necessary. Mr. Bhuya, you are appearing for who are they? Higher education. Also heard as Bhuya, standing counsel, higher education department. In view of the above, the Department of Public Works is granted time of 3 weeks to obtain the instructions / file affidavit in opposition of para. Since a recruitment process is involved, wherein there is also an interim order, the matter is directed to be listed on date. Mr. Mohanta, date.
My lord.
Date 30. 1, 2. We'll have it on 21st. 3 weeks. And informally, we are under understanding that if the affidavit come, we'll go for final.
My lord.
Actually, in item number 6, we are qualified candidates. We only want the result. And moreover, Lordship, one another recruitment process for the same post has already commenced. Now examination is over, results are to be.
Why is your thing held up? If you are qualified?
Yes,
No,
Lordship.
they are qualified. They are civil engineering. They had no dispute, my lord. The candidacy has not been rejected. They are appearing. Their interview has been.
How is it different from Mr. Das's?
Because we are unable to publish the result because already there is a order from the Honorable Court to keep vacant 92 posts. So since out of 1307, 92 posts we keep vacant, then my lord, if the department is stuck as to roster system, my lord.
You are yet to be appointed.
So then we can do it, my lord.
You are yet to be appointed. You may be within these 92 vacancies. We'll have to hear together.
No, he is not in 92.
No,
Oh,
understood.
yes.
If 92 posts are kept, are allowed to be filled up, he may get a chance. We'll hear together.
I am not seeking appointment, I am just seeking the result. Lord,
No, results are 92 have been asked by this court to be kept intact. Will depend on the order of this court.
Only
Today, if we direct your consideration or declaration of result, their chances of being considered will also be extinguished. Tomorrow, if they are not successful, then 92 will be filled up by all the other persons. But if they are successful, then they will not have a chance. It's only for that matter that yes.
So, my lord, can it be on 19, my lord? 21st of
No problem. I'll be always.
More important, my lord.
19, Mr. Nayak, 91, 19 September.
Much time for the respondent, the petition is yet.
The day, day.
Yes, Lord.
It is Peter's Day.
Yes.
He is celebrating Maligaon Fire. I'm sure. Matter of 2022, what is the matter?
It's about VRS, Lord, voluntary retirement application.
Okay, we'll do one thing. Would not like to just adjourn this matter. Too early to rise. Look out for him. Whenever he comes, inform.
Okay.
If he doesn't come, we'll pass an order because this is not an old matter. Otherwise, there is one has.
Not today, Lordship.
Huh?
After a week, Lordship, not today.
No, no, you take the court file. You cannot rise the deduction of
It's regarding the
on the
acceptance of
different
the,
on a different day we cannot finish matters.
Right.
And today you cannot rise it.
it's regarding the acceptance of the application of VRS, Lordship.
You if
The
prepare the
petitioner-
case, let Mr. Day come from him. Or you just inform the court master will come.
Yes, yes.
You can write some judgments in the order. Yes, but you prepare yourself. We'll hear you. We'll not adjourn this matter if you come. Please inform the court.
Yes.
It's really celebrating, but my lord, I have got traffic jam from the bridge at Kamakya Gate
Today,
up to Borolomuk,
even today.
even today.
Why?
Well, Borolomuk traffic jam is there, my lord. There is no from Maligaon side, but now the jam started from Borolomuk towards. I was waiting for it from the overbridge. It seen that Borolomuk jam is there.
But we have heard that something is going to happen tomorrow. Have good news.
It's a Maligaon traffic jam is
In
gone, my lord.
celebration
Now
of Maligaon Bridge, you are doing something tomorrow.
newly starts Borolomuk jam,
Yes, tell us.
my lord.
What is the matter about?
My lord, matter relates to voluntary retirement of the petitioner, my lord. The petitioner, my lord, initially appointed as a LDA in 1986. He joined on 7/11/1986 in his duties.
Which department?
Executive
Agriculture department.
Executive Engineer, Agriculture Department.
You joined when?
7/11/1986
As?
as LDA, Lower Divisional Assistant.
7, 7. Petitioner joined as LDA.
LDA.
Which office?
My lord, in the office of the Executive Engineer, Jorhat.
Yes.
Thereafter, my lord, he was transferred to Dibrugarh.
When?
In 2002, my lord.
Yes.
When he was serving as the LDA in the Dibrugarh, my lord, he was fell ill due to tuberculosis, TB.
Yes. Yeah.
And my lord, he has to suffer for a lot,
Yes.
my lord. And he submitted several applications for medical leave, and some of the applications was granted, and subsequently he filed another application 25/3/2024, 2004. That was, my lord, no order has been passed. My lord, extension was seeked in by that application. That was not granted. Subsequently, my lord, as he was not cured and he was not physically fit, my lord, so he submitted a application for voluntary retirement on, my lord, 29 March 2007.
Yes.
My lord, that application I have annexed as page P2, annexer P2, page 19.
19.
19.
Yes.
My lord, that application, my lord, the respondent authorities neither accepted nor rejected, my lord.
That is 19.
Page 19, my lord. My lord, last paragraph, considering the above circumstances, I have decided to go for voluntary retirement from 1/4/2007 after completing my
Yes,
service.
thereafter,
My lord, thereafter, my lord, the respondent authority did not accept it nor rejected it. It kept pending. And the subsequently, my lord, in 2011, my lord, a disciplinary proceedings was initiated against him.
Hmm.
Stating that he was unauthorizedly absent, my lord, with effect from 1/10/2002.
which is the date,
My lord,
date of issuance of memo charge,
my lord, that is page 20, my lord.
8 to 21 or 8 to 11,
That is the show cause, my
8
lord,
to 11, 20.
20.
So called notice.
20, show cause notice.
Yes.
That he was unauthorizedly absent and the disciplinary proceedings was initiated, and my lord, the petitioner submitted a reply, page 23, 21 to 2011. And my lord, thereafter a series of correspondence has been made between the respondent authorities. But my lord, in the meantime, my lord, the inquiry officer has submitted a report, page 25.
25.
25. Holding that, my lord, that he was remained absent from official duties from 1/10/2002. And thereafter, a show cause notice was issued on the basis of this.
What is the date of this inquiry for 31/8?
My lord, the report,
Date is 31/8/11
my lord,
of the year inquiry
My lord.
report.
31/10/2011.
10 or 8 or 10, 10.
10.
Yes.
Thereafter, my lord, another show cause notice was issued to the petitioner, and he has given another reply, my lord, that page 27. 27.
Yes.
Denying the, my lord, allegations. And also requested to grant the, accept the voluntary retirement application, my lord.
Yes. You replied.
Yes, my lord, the reply is given, that is page 27.
Right when? 15?
15/3/2012.
Yes.
My lord, thereafter, my lord, no action has been taken from the government side, and the petitioner has challenged that disciplinary proceedings by a writ petition before this honorable court. And this honorable court, my lord,
What is the
that annexer P12, page 32.
double 567?
My lord, 5567/2018.
Challenging the DP.
My lord, that challenging the DP show cause, my lord.
Okay.
And this honorable court, my lord, by the order dated 35/2022, my lord, has quashed and set aside the disciplinary proceedings, show cause, notice, inquiry report, etc.
Okay.
And direction was given by that writ petition, the respondent authorities to consider the application for voluntary retirement within a period of 8 weeks.
Yes.
My lord, thereafter, my lord, the petitioner submitted the certified copy to the respondent authorities, and the respondent authorities, my lord, passed the impugned order, that is page 45, my lord. Annexer P15, whereby rejected the petitioner's application for voluntary retirement. On the ground that, my lord, the petitioner has not completed 20 years of service period. Hence this petition, my lord. My lord, prima facie, my lord, from the reading of this impugned order, my lord, last paragraph, page 46. It is seen that, my lord, they have calculated the period up to 2002, whereas the petitioner has submitted the application in 2007. Even if, my lord, this honorable court by earlier order, my lord, held that page 37, my lord, finding one finding, my lord, page 37.
Yes.
My lord, may I read from beginning, my lord? If an employee voluntarily absent from himself from duty from a particular date, such an employee can be treated as a person who is not in service. In absence of any materials in this regard, even if the contention of the respondent is accepted, that on 29/3/2007, when he had applied for voluntary retirement, the petitioner did not have 20 years of qualifying service. Nonetheless, during the pendency of the disciplinary inquiry against the petitioner, there can be no doubt that the petitioner had completed 20 years of service, taking into account the stand of both sides that the petitioner had joined service on 7/11/1986. So, my lord,
Yes.
my lord, the petitioner, if I would calculate the, my lord, service period, my lord, from 86, he has in service, my lord, continuous service, my lord, that 20 years, about 5 months, my lord. So he has qualified for the voluntary retirement.
Yes.
And the, my lord, law is well settled, my lord, your lordship knows that if an application for voluntary retirement is submitted, that application is to be considered within a period of 3 months, my lord. If the respondent authorities failed to consider that application either accepted or rejected, then, my lord, it is deemed to be accepted. The application is accepted, my lord. And now they have filed my lord, affidavit stating that the petitioner has not completed the required age, service period. On the ground that, my lord, they are taking that the petitioner has unauthorizedly absent from duties with effect from 1/10/2002. My lord, that point cannot be raised after the judgment of this honorable court because the disciplinary proceedings initiated on the basis of, my lord, allegation that he was unauthorizedly absent, and that disciplinary proceedings has been set aside and quashed by this honorable court. Now they cannot take plea again that he was unauthorizedly absent with effect from 1/10/2002, my lord.
Where is this report of the inquiry made on 8/2020?
My lord, it is in their affidavit, it is given, my lord. Annexure 1, page 54. And this inquiry, my lord, fresh inquiry for the same allegations, my lord, is in violation of this honorable court's order, my lord. As because this honorable court has already set aside the disciplinary proceedings, including inquiry report, my lord. This is nothing but a true copy of the earlier report, my lord, inquiry report.
Yes.
My lord, page 55, my lord, their affidavit. these things are already discussed. From my lord, middle, regarding the leave applications and sanction letters submitted by Saurabh Borua, junior assistant under establishment, that is from so and so period, my lord, 1/10/2002 to 29/12 to 2002, 30/12/2002 to 29/3/2003, 33/2023 to 27/6/2003. These are already discussed in the earlier inquiry report, my lord. All the things in the earlier report it is discussed, and that report has been satisfied by this honorable court. Conclusion, my lord, page 56.
Yes.
My lord, their ultimate, my lord, that contention is that as per entry, my lord, 11th line from bottom, 11th line from bottom, my lord, as per the entry, right side from right side, my lord, as per the entry in the service book of Sri Saurabh Borua, junior assistant, it is seen that he was unauthorized absent from 1/10/2002 in office. There was no evidence or correspondence or contract by Sri Saurabh Borua has been found after publication of the advertisement Dainik Janambhumi 9 July 2006. I have not seen any evidence of Saurabh Borua has been intimated the
Yes.
competent. My lord, these are already, my lord, these things are the earlier inquiry report, all these things have been discussed, my lord. And this honorable
those
court,
have been satisfied by this court.
my lord,
In fact, the entire charge of unauthorized absence has been interfered.
my lord,
CP has been passed.
what?
Now, can you think that we can go back?
But Lordship, he doesn't qualify for submitting his application for voluntary retirement because he was unauthorized absent from 2002.
That unauthorized absence has been satisfied by this court. How to come to the conclusion that he was unauthorized absent?
Since 2002, Lordship. On
How do you come to the conclusion? That was the issue in the court. Court has interfered with your finding.
of the DP because of the delay in the DP, Lordship.
Doesn't matter.
That was the
Oh,
lectures in our part, Lordship, because of the delay of the DP.
The allegation of unauthorized absence, which was the subject matter of the DP, and it was in fact the full charge, that has been interfered with. Now, having interfered, you can challenge the order of the honorable single judge. You did not.
Yeah, that is
You allowed the attend finality. Honorable single judge had directed to pass order on the application for VR.
Yeah.
That application has been considered by taking into the observation of the court. You cannot re-enter the reopen the case which has already been closed by this. You may have something on fact, but to have that liberty to reopen the case on fact, you have to have a clarification, either file a review or go to the appellate court, which you have not done. Now, this observation of this particular inquiry officer at page 56, that it is seen that he was unauthorized absent from so. He does not have the jurisdiction to say so. That unauthorized absence delegation has been satisfied by the court. Absent is one thing, unauthorized absence is a different thing. Absence without any reason or without any intimation may amount to unauthorized absence. But if there were circumstances for which he could not attend the office.
No, Lordship, he did not intimate. We have given a paper publication on
That is it. The explanation of yours was already considered and rejected.
That is true, Lord.
After that, we cannot reopen.
But his conduct, Lordship, once he thought that he qualified for VRS by the year 2007, he submitted the application for VRS. But since 2002, he was absent. 2006, we gave a paper publication calling him on duty, Lordship. He did not attend the office.
See, the order of all this submission of yours will not have any meaning, madam, because on 35/2022, we have an order of this High Court,
Yes, that is
which has taken into consideration all your submissions, rejected. You don't have this scope. You can get this scope. You should have got this. If you are not satisfied with it,
filing a
you should have filed a filed an appeal which have not done. Third, PCD Senate Council for the petition, whereas the Department of Agriculture is represented by MS R. Bora. Correct. The extraordinary jurisdiction of the court conferred by Article 56 of the Constitution is being sought invoked by the petitioner who has put the challenge and ordered it 4/8/2020 passed by the Director of Agriculture, by which the application for voluntary retirement has been rejected. The principal ground of such rejection is that the petitioner did not have the eligibility criteria of having completed 20 years of service. Before going to the issue which has arisen for determination, the basic fact of this can put in a nutshell in the following. The petitioner was appointed as an LDA on 7/7/9 and was posted in the office of executive engineer from Jorhat Division of Agricultural Department from a government. So he was transferred to Dibrugarh in the year 2002. However, he had suffered from tuberculosis and accordingly had applied for medical leave. It is the case of the petition that his application for extension of medical leave was however not granted, and therefore, having no other alternative, on 29/3/2007, the petition has submitted an application for voluntary retirement. The said application was not responded to by the department, and on the other hand, a disciplinary proceeding was initiated by issuing a show cause notice dated 8/2/2011. The track of the two charges is with regard unauthorized absence from 1/10/2002 till 1/1/2010.
It is 400.
Therefore, 1/1/2010, and it has further been alleged that in spite of notice being published in the newspaper, the petitioner did not resume his duties. The state show cause notice was replied to by the petition on 21/2/2011, whereafter an inquiry was conducted and a report was submitted on 31/10/2011, whereby the charges were held to prove. The petitioner was thereafter issued a second show cause notice on 9/11/2011 on the acceptability of the inquiry report, which was also replied by the petition on 15/6/2012. Thereafter, at that stage, the petitioner had approached this court by filing WP 557 of 2008, wherein the entire disciplinary procedure was to challenge. Thereafter, this court, by an elaborate judgment in order date 35/2020, had however set aside the entire disciplinary and had directed the authority to consider the application for voluntary retirement within 8 months. It is it is in pursuant that an exercise was conducted which has culminated on the date 8/2/2022, whereby the application for voluntary retirement has been taken. As already recorded above, the primary ground of rejection is non-completion of 20 years of service. There are three days the learned counsel for the petition has submitted that the disciplinary authority has committed manifest error in law in rejecting the application, which is the teeth of the observation made by this court in the judgment and order in 35/2022, asked in the aforesaid WP 5567 of 28, received by the petitioner earlier. He submits that the period of 20 years appears to have been calculated only up to 2002, whereas the application for year was submitted the year 2007, by which time the petitioner had already completed 20 years of service. The learned counsel for the petitioner has drawn the attention of the court to the relevant part of judgment dated 35/2022, wherein this court had come a definite finding that the petitioner had completed 20 years of service, and therefore it is submitted that the same issue could not have been reopened. Today, the learned counsel according to submission that the impugning order dated
4/8.
4/8/2020 is liable to be satisfied and a direction to be given for passing appropriate orders except is except the voluntary return of the petition. This you are submitting,
Well,
Jacob, and it is
yes, yes.
Lordship, I submitted
Some
for breaking service.
judgments, my lord, I have submitted
I
in
have
earlier
submitted
occasion.
two judgments.
and see Jacob and here
Yes, yes, Lordship.
your case.
Yes.
Where are your judgments?
My lord, I have submitted earlier, my lord, it is in the file, my lord. My lord, first, the Dr. Prabhas Chandra Sharma.
Second file, please. Yes.
Prabhas Chandra Sharma. Paragraph, my lord, 21.
In support of the the learned counsel for the petition has based reliance upon following case laws. WP 3838 of 2020
Judgment dated 2/5/23.
for Dr. Prabhas Chandra Sharma. Judgment date 2/5/2020. Which paragraph?
Paragraph 21, my lord.
Yes. Next.
Next, my lord,
Altaf.
2000, Altaf Hussain.
Next.
Paragraph 20.
4 GL
4 GLT 297. Paragraph 22.
Hussain Lasper. Yes, next.
Then, my lord, 2019 1 GLT
91
138. Paragraph 31, 33, and 35. 31, 33, and 35.
Look at time. Time. Nikio.
I Nikki.
Yeah.
Next, my lord,
Zahir Muzaffir.
my lord, section 2021 3 SCC 290. Paragraph 31, 32. 2001 3 SCC. Name, my lord, Tech Chand. Is not there. Then I will submit, my lord. On that. Then 1977 4 SCC, that is, my lord, Dinesh Chandra Sangma's case.
1977.
4 SCC, page 441.
Dinesh Chandra Sangma.
My lord.
Yeah.
Then, my lord, 1995.
Dinesh Chandra Sangma, which paragraph?
Dinesh Chandra Sangma, paragraph 13, 17, and 18.
1995, supply 1.
1990, yes, my lord. Supply 1, 76. Union of India versus I Muzaffir Mir.
I SAY Muzaffar.
Page 5, paragraph 5. My lord.
Tirot Purva, no.
Hello?
Tirot Purva.
Tirot Purva, I have not.
What about C. Jacob? C. Jacob and
Paragraph 12, Lordship.
you have
Yes, yes.
in the case of Punjab. Per contra, comma. And both of them standing for the department. a valiant attempt to defend the action of the respondent, which has rejected the application for VR. It is submitted by her that the petitioner was unauthorizedly absent from 2020 from 2002, and in spite of notice being published in the newspaper, he did not attend office, and therefore the calculation has to be done only up to 2000, in which case the petitioner does not meet the minimum requirement of having 20 years of qualifying service. The understanding of by referring affidavit in opposition dated 18/5/2023 has submitted that the interim order, that the impugned order was preceded by an inquiry report dated 1/8/2020, which and as per which the aforesaid findings were arrived at, and therefore the state fixed order does not suffer from any information. The understanding council lastly submits that this court, while allowing the earlier WP 5567 of 2018 by the order dated 35/22, had directed consideration of the application of the PR which has been done, and having found that the petition did not meet the requirement, did not meet the requisite qualification with regard to the minimum length of service, the order has been passed. The understanding council submits that since the order is based on relevant tradition, does not warrant any interference, and according to is submitted that it is been in support of our submission, the standing council for us has based time upon the following case. C. Jacob, Sarah,
12.
12.
12.
C. Jacob versus Director of Geology and Mining, reported 2008, NS 115. Vijay S. Sathaya, Sarah,
12.
Vijay Sathaya,
Yes, yes.
reported in 2013, NS 25.
Previous one was 11, 12, and 13. Previous one was Jacob is 11, 12, and 13.
In the case of the rival condition of the internal council part habitat habitat. There is no dispute. The proposal of law advanced by the council was department, who has also died of the decision of the Honorable Supreme Court on the point of unauthorized substance. The Honorable Supreme Court has laid down that any government servant who abandons service in spite of being notified cannot be treated to have continued in service. While, while there is no dispute with regard to aforesaid principle, while there cannot be any second opinion regarding aforesaid principle laid down by the Honorable Supreme Court, what is of importance in this case is that the issue regarding the allegation of unauthorized absence was already examined, was already the subject matter of examination in the earlier writ petition filed by the petition, namely the WP 5567 of
2008.
2018. In the judgment and order dated 35/2022, while the disciplinary proceeding which was initiated on the principal allegation of unauthorized absence was satisfied, this court in paragraph 10 has made had come to the following finding. Paragraph 10. Though MS Bora may be correct in contending that ultimately the Director of Agriculture, Assam, was left to take a decision on the application for voluntary retirement dated 29/3/2007 of the petition, such application, such consideration is essentially required to be made by following the observation of this court in the judgment, as the state part of the judgment is only a consequential order after recording the finding as would appear from the other parts of the judgment. Also, it is also not a dispute that the department did not file any appeal or any review of the state judge, and according the same has attained finality, and therefore there cannot be any second opinion on the issue that the charge of unauthorized absence based upon which the DP was initiated was interfered with by the court. Also, that being the position, the state issue could not have been reopened by the authority which however, appears to have been done from a reading of speaking order, impugned speaking order dated 4/8/2022. This court is also perturbed by the fact that the impugned order dated 4/8/2022 appears to have been based upon a press inquiry report dated 1/8/2022, which has been annexed to the affidavit of opposition as Annexure 1, in which, the entire issue regarding the allegation of unauthorized absence has been sought to be reopened. Has not only been sought to be reopened, but a finding which is in the teeth of the observation and finding of this court in the judgment date 35/2020 has been made in the conclusion of the state report submitted by the Joint Director of Agriculture, a finding has been arrived at that a finding has been arrived at to the effect that as per the entry in the service book of the petition, he is seen to be unauthorizedly absent from 1/10/2002 in the office. In the opinion of this court, such findings are not only unwarranted, but also appears to be contemptuous in view of clear findings of this court in the earlier judgment and order dated 35/2020, which, as observed above, has attained findings. This court is of the unhesitant opinion that the scope of passing the final orders pursuant direction of the court in its judgment and order dated 35/2022 was a limited one, which was to be exercised by taking into consideration the observation and findings of the court in which the allegation of unauthorized was interfered with and the entire DP was set aside. In view of the above, this court is of the opinion that a case of interference is made out, and accordingly it is directed, and accordingly, the impugned speaking order dated 4/8/2022 passed by the Director of Agriculture is set aside. The appropriate authority is accordingly directed to pass immediate orders of acceptance of voluntary retirement of the petition in terms of the by following the findings and observations of this court made in the earlier judgment and order date 35/2020 passed in the applicable 5567 of 2000. The aforesaid exercise is to be carried out and completed within a period of 45 days from today.
Well, so for the pension and other service benefit may be also
That it is needless to state that the authorities are also required to consider the aspect of post-retirement benefit which would accrue to the petition in accordance with.
deeply appreciated.
The day tomorrow? No, what does that mean tomorrow?
Your lordship also welcome to come.